we go to the boards, let them know we have 3 people who haven't paid. We're at 45 days. Can we turn it over to the association? And that's where you guys do your magic.
And I'm going to jump in, give a little more context, Lisa, for the association side of it. There really should be an 8.5 by 11 piece of paper. At the top of it, it's going to say resolution. So it's a board resolution that can be easily found from year to year as that board changes. And it's going to say collection process. And every association is going to be slightly different. In your case, the one you just raised, okay, they're delinquent, 15 days, they're going to get the first letter. Maybe then it goes on, 30 days goes by, and maybe they get a second letter. Every association is slightly different. And I take it Lang is able to accommodate all those differences for the different personalities of the associations. And the NOLA you refer to, cute name, but that's a new statutory requirement. And this is not a letter that you all have a choice out there of sending. The statutes, 720, 718, condos and homeowner associations require, Florida legislature requires a certain letter that has to be sent within the correct format as dictated by the legislation. And we even prefer that the management company complete an affidavit before turning it over to us that creates a presumption of validity regarding that 30-day notice that it was actually sent. So if we have a problem in court and they allege it wasn't, we have that affidavit. It's part of the statutory process. Alan, you want to jump in on some of the unique collection? You used to solely do collections. I never solely did them, but as a younger lawyer, I was very involved with the collection department and started one at another law firm and all that good stuff. And I know you were very involved in Kaye Rembaum for a period of time as well, long before being my partner.
Yeah, I mean, I've done way more of that type of work than frankly I might have liked. I now speak on it at the board certification exam prep class for other attorneys every year. So yeah, I have a little bit of experience, only about 15 years worth of collection. Some of the things that I'll add, and thanks for the opportunity to kick in, Jeff. First of all, this is not the NOLA that I like. The one I enjoy is the one that has beignets and jazz. But you know, this is a notice that was never required until a couple of years ago, as you guys mentioned. And it's really intended to be the one notice that everyone is entitled to get before the attorney's fees kick in. And I think that's the thing that people need to understand is this is your opportunity to avoid paying a firm like Kaye Rembaum a bunch more money instead of just paying your assessments on time. The other thing that I will add when it comes to these policies, I know that it was mentioned very briefly by Lisa that, you know, the policy essentially says the board gets to see which accounts are delinquent and decide what to do with them. My preference personally is that it doesn't go to the board for a decision. That resolution simply says if the account is still delinquent after the 30 days are up, it goes to counsel. Some communities don't want to be quite that aggressive, but the item that we're talking about today when it comes to collection of assessments is literally the lifeblood of your community. If you don't do that collection and you let people just sit there delinquent for months to years at a time, what you're doing is guaranteeing that everyone else in the community is covering their expenses.
And what about, Alan, what about the board that refuses to take collection activity? Let's say I'm just looking at some of the Q&A and we have someone who's been 2 years delinquent. The board has done nothing. Not looking into what we can do with the delinquent owner, but let's say another owner is upset that the board isn't taking action. What type of cause of action do you think that board member could be, the entire board could be subjected to?
Yeah, I mean, I think I won't say it's a clear breach of fiduciary duty, but the bottom line is the directors have a legal responsibility to do what's in the best interest of the association.
So it never should be 2 years behind then, right?
Right. I mean, I don't know that anyone could reasonably argue that allowing an account to go delinquent and leaving it sitting there for 2 years is ever in the best interest of the association, unless there's some very specific reason. I don't think we'll have time to get into bankruptcy today, but you might not be allowed to move that account forward for 2 years, but they should be paying under the bankruptcy plan. If there's a mortgage foreclosure action pending, it's up to the board, but you should be pushing that mortgage foreclosure action forward, in my opinion. So, I mean, Jeff, to your point, I can't imagine any circumstance where just letting that sit for 2 years would not qualify as a potential breach of fiduciary duty, beyond the fact that, again, you're giving that 2 years to all of your members to cover this person's expenses. Because keep in mind, what are these assessments what do they represent? They represent what the association budgeted to actually be able to cover expenses to properly operate and maintain the association's facilities, operate the corporation. And if you've got special assessments, you've got a specific purpose that was intended for. So if people aren't paying these things, the association can't be maintained and operated the way that the board is obligated to do. So what the board is doing by not moving forward is pretty much guaranteeing you can't operate properly.
Makes sense. Lisa, did you have anything else you wanted to add regarding the Lang's ability to assist the board with creating the collection policy? Because you want to make sure that every member is treated the same. If you don't treat everyone the same and you send a collection letter to Joe, but not to Alice, or a late letter, you charge one interest, but not the other, what a world of problems we are creating.
It's definitely a challenge. And, to Alan's, we do have issues that, oh, I know him, he's got a special situation, but you can't. Everybody needs to be treated the same. And I think more so in the last couple of years, we've had more of collection issues that are going straight to the attorney because, just of the economy.
Well, and Lisa, one other thing to remember when you get the, oh, I know him, if you're on the board, you need to understand that when Jeff brings up that breach of fiduciary duty, you're running a business. Whether you want to be running a business or not, that's what you signed up for. So you have to make business decisions on behalf of the corporation that you work with. Whether you're being paid or not is irrelevant. You have that same obligation. So I know the guy, he's my neighbor, he's a good dude, frankly, does not change the decision that you are legally obligated to make.
And I want to answer
that reference a lot. We make that reference a lot, that this is a business. It's not, this is your money. You have to manage it and make sure everybody's doing what they need to do to their part to run the business successfully.
So you need to budget for the collection process. The association isn't going to be able to recapture some of the money it spends with the management company on the pre-attorney, let's say, part of the collection process. It's just part of doing business. You need to build it into your budget. As to the questions you all are asking, they're good questions. I'm going to ask that you stick around to the very, very end, and we're going to try to do a shotgun answer on anything we don't answer during the webinar presentation. So the last couple of minutes, Alan and I will try to shotgun it. But before that, who's responsible for sending the 30-day NOLA letter? Stephen Epstein asks. And essentially, that is the association, but it typically, obviously, unless you're self-managed or you don't have a manager, it's going to be the management company who is doing that. But the management company needs direction from the board to do that, which is why you need your collection policy. So that's, yep.
Sorry, just one of the things to jump in while you're talking on a collection policy. There's many times where board members will say they want to make a phone call. As Lisa said, they know somebody, they're going to call them. Well, you don't want to selectively call people, and we don't have the property managers call because we don't want anyone from our company to be misrepresented, that we made some type of deal with an owner that shouldn't have been made, that, it's a he said, she said on that call. But we do recommend that we email whatever last notice we're sending out before we send it to the attorney. We do for some of the boards that would like that. We email that to the owner's email of record so that we've tried every way possible to contact them before it's turned over.
And to Daniel's question, since you brought up notice, the required, where do you notice the member? At their official address, whatever they've given to the association for their official communications. If you have other addresses and you want to use them, that's fine. We can't. So attorneys are considered debt collectors. We stick to where we know the person actually is, the official address given to the association and such. We don't want to take a chance of sharing that debt with somebody who's not supposed to have it. Management companies to present date are not considered debt collectors under the federal statute. We're going to talk about the state statute that we all have to live with later on in this presentation, but the association is not a debt collector. So the association and management company have the ability to get in touch in ways that the attorneys don't. To your point, Marita, at our association, believe it or not, before it goes to the attorney, the manager actually does pick up the phone, a short phone call. Hey, can you call me back at the management office? We have an issue we need to discuss. They call back, she shares with them the delinquency, and it seems to resolve quite a bit of that with that friendly phone call. We don't say, hey, call us back, you owe money. Nothing like that. It's just a call from the management company. If the person answers, great. If they don't, leave a message, hey, please call me back. And then when they do, they have the conversation, and it seems effective, but we're only 127 homes, so it's easier for us than maybe some of the big ones. But Wendy, I hope I answered your question. It needs to go to the official address. If they've opted in for email, it's email. Otherwise, it's their address in the association, unless they've given you an alternative address. All right, moving right along, Marita, this is your show, so you probably want to start talking about the association collection process, which we just did. Internal processes, policies, what happens when it goes to the attorney? Do we want to bring it all the way to what happens when it comes to us?
We're up to that point. I think at this point, with them adopting what their policy is, we follow it. Accounting department sends it over to you. You want to take it from there, Jeff?
Sure. I'm going to turn it over to Alan in just a second, but when you turn it over to us, we need a couple of things as the attorneys. We need a ledger that goes back to the last time the owner paid in full. I typically refer to it as a ledger that goes back to the last 0.00 balance, but you understand what I mean. We have to be able to track back with certainty all the money that is owed. So that's one thing we absolutely need. Number two, we need the 30-day letter that the association sent out by and through its management company, typically along with the affidavit. It's helpful. And then finally, we also would like to have the association management company fill out an authorization to commence the collection. It gives on that form, it's an 8.5 by 11. At least we have physical authority, if you will, a signature that we need to proceed. It gives us the official address, things like that. And Alan, why don't you take it from there?
All right, so once we have all that information, we can get our file open internally and we'll send what's called a notice of intent to file a claim of lien. That's a lot of words to say. Either pay us within these 45 days that we're providing you, or we'll file a lien against your property. Now, I've actually had people ask what a lien is, so let me go through. It's basically something that gets recorded in the county public records and says, this property owes me this much money, me being the association. And so it's essentially recording a document that states you owe money. Now, we won't get into priority of liens, but it basically establishes that if anyone else is going to lend money, close on a transaction, etc., there's now something that shows up on a title search that says this property, this particular lot, this particular unit owes money to the association. So that if someone is requesting an estoppel certificate in connection with a closing of a mortgage, a closing of a sale, that's going to pop up on that title search that they find, and they're going to know that they need to, the title agent needs to reach out to the association. So this 45-day letter, like Jeff mentioned earlier, is going to go only to the mailing address that's been provided by the owner and to the property address. It goes out via certified mail, return receipt requested, copy be regular mail. And then once that expires, if the owner still hasn't paid, and when I say paid, I mean in full. I don't mean they owed 10 grand and they paid you 500, so you have to start over. Doesn't work that way. You just apply it in when you're recording the lien and when you are going forward with your next notice, which we'll get into in a second. Now, going back to payments, management needs to make sure that the attorney is aware that, hey, this account is in collection, we got a payment, you need to apply it. Because if we don't know about that, our firm is wise enough to reach out to management before we take that next step and send any kind of payoff information. But if you've received a payment and we don't know about it, we're sending inaccurate information. Jeff and I will get into later what that means under the Fair Debt, actually the Florida Fair Debt Practices Act. So we'll move on. Going forward to the lien, I've explained what that is, but once that first notice expires, you can go ahead and send out your lien, get it recorded. And at the same time, once it's recorded or once it's being sent, different attorneys feel differently about this issue, so I won't get into it. But you can go ahead and send out your last pre-suit notice, which is your notice of intent to foreclose a claim of lien. What you're saying in that letter is you've got yet another 45 days. And by the way, that 120-day time frame is why I say don't wait. I think that Lang is doing it right by saying don't wait 6 months before you start this process and basically guarantee that the owner's going to get a year before they're actually in foreclosure after they were not paying. But back to what we were talking about, this is another notice. It's 45 days, sent the same way, says pretty much the same things. The big distinction between this and the notice of intent to lien is that it says if you don't pay within these 45 days, we will file a foreclosure action against your property. Now, what that means is we're going to file a lawsuit. It's going to ask for two things. It's going to say that there was a breach of the contract. It's going to ask for damages. This is against the owners. Okay, then we're also going to try and foreclose. That means we're asking the judge for a foreclosure sale date. And what we're asking for is also to foreclose out any other interests that we have the ability to knock out, so that those liens don't stay on the property after our foreclosure is done. So that's the pre-suit phase and kind of starting to get into the actual lawsuit. Jeff, I don't know how far we wanted to go during this segment, so to speak, and whether you've got thoughts, because I've spoken for a little while. Let me open it up to you a little bit.
Just regarding the litigation itself, sometimes somebody asked a question about a default judgment, and I will help our audience understand that process. So when the defendant does not respond to the complaint, so we've now gone through the 30-day letter sent by the management company, the 45-day letter intent to lien. Hey, if you don't pay your debt, there's going to be a lien recorded against your property, followed by the intent to foreclose. Again, a 45-day hold on that one. And then afterwards, then you can begin the foreclosure action. You did, you named the debtor didn't respond. The clerk automatically enters a default judgment against the defendant. However, the attorney then has to file a motion in court to convert that default judgment into a final default judgment. So whoever asked that question, there is your answer as far as process goes in the courtroom. And these cases, they can take many, many, many twists and turns along the way. And this is why we want the associations, before the collection comes to us, to dot all the I's, to cross all the T's, because it's a very exacting process, and one misstep can lead to a judgment in favor of a debtor. So that kind of handles that. So that's what happens when it gets sent to the attorney. The first time through, we review the 30-day letter to make sure it's statutorily compliant. So there's a small billing entry for that. It doesn't take long to do, but we have to make sure you are statutorily compliant in that regard. Let's see, where do we want to go next? I suppose, go ahead.
Jump in for 1 second, because
Yeah.
I just want to build on what you just said. If you are not using a management firm, my recommendation is that you not just go ahead and create a form for the notice of late assessment and affidavit that you think will work. We will prepare that for the associations we work with.
Or
to
your
make
lawyer,
sure
right?
it's done the right way.
Right. So, and by the way, nothing we're talking about today should be construed as legal advice. We're talking in broad stroke generalities here. So again, if you have specific questions that really need a legal answer, you're going to have to go to the association's attorney to discuss those types of things. Again, just general advice for today. Where should we go next?
So one of the biggest challenges at this point with our associations is to foreclose or not to foreclose. And I know you're going to discuss this at length, but I will add to it that you may want to discuss some of our associations that do talk about the foreclosure. Don't keep in mind that there may be a master association that has dues or club dues that may have to be paid if they do foreclose on a property. So that's conversations that we end up having before they move forward with a foreclosure. So just keep that in mind. If in your association you're considering that, you might want to make sure you check your master association and have your attorney check into that to find out what your responsibilities would be. That's part of the reason some of our associations don't foreclose on a property, because they could be taking on a larger liability than they want to for the association. And with that,
or maybe, you know, to your point, maybe there's a first mortgage out there. Maybe the first maybe they're not getting paid as well, and the lender has priority over the association. So we wouldn't want to see the association spend thousands of dollars only to then be stymied during its foreclosure case because it has to take a backseat to the lender. And that can happen as well. So there are exceptions to every rule. So when somebody asked that question, it was, what if our assessments are de minimis? Should we really be spending thousands on collections? To which I responded, I after E, except after C, right? There's exceptions to every rule. You need to exercise these decisions using your reasonable business judgment. And reasonable business judgment is typically always a defense to someone who's saying, hey, you're not doing your job. Well, you made an educated decision. You might be right, you might be wrong, but maybe you made business sense in deciding not to foreclose because of the first mortgage, because of the club due obligation, because of. So there's lots of different items that go into these analyses, and not every single case is the same. Let's say the case winds its way through the court system, and now there's an auction that's going to take place, and the lender ends up entitled, or alternatively, maybe it was the lender foreclosure, maybe it was the association foreclosure, but instead Joe Schmo goes to the auction and he's the highest bidder. So I think the audience needs to know what the lender is going to be responsible for and what the third party bidder who wins the auction is going to be responsible for. And we can answer one question with certainty, right, Alan? We can answer the lender question with certainty. So the lender's going to owe 12 months back assessments, or 12 months back assessments, or 1% of the initial mortgage, whichever is less. And that's just the reason that's in the law is because, well, gosh, when you buy your house, you want your lenders to be in a position to make loans. So they have to know what their liability is. We want to encourage them to come into the state of Florida to write these loans. So they do. But then we get into an issue with the third party investor who is not protected in the legislation. In fact, the legislation would tell you that they have joint and several liability for the prior assessment debt of the prior owner. But Alan, it doesn't always work out that way, does it? How come?
Because the courts don't like us, Jeff. The courts decide that, just like we would argue that certain things shouldn't impact the existence of a contractual relationship, just like we would say that some of the new laws that have come out in 2024 shouldn't impact our association, which I believe we touched on in either number 1 or 2 of this series. These third parties are able to make the argument that they're able to rely on language that's in the declaration as well, because if that language that protects these third parties wasn't there, they never would have bid. Because of course, these third-party bidders are taking the time to go out and pull up the declaration of every community association where they bid on property. I'm going to call, this is the legal term, BS. But the fact that it is recorded means that there's the possibility that they went and looked at the documents, and they had a right, according to Florida case law, to rely on what's in there. And so to shorten what I could be saying...
Wait, because I don't want to confuse everybody. I want to get to what's in the declaration. So I'm going to short track that just so everybody is on the same page as us. And that is, notwithstanding the fact the law says joint and several liability, the declaration says in plain black and white English, third party purchaser, as a result of the auction that takes place because of a foreclosure, has to pay nothing. They get a complete pass. And then you get this discrepancy between the legislation and the declaration. And of course, the court's going to go with the declaration on that instance every time. And Alan, the name of that case, that famous case is?
Hoffman versus Scheer.
Oh, no, I was going with Pudlett.
Oh, you're talking specific to foreclosures.
Yeah, specific to foreclosure, where the language of the declaration, that was a case where a third-party investor said, hey, I don't have to pay anything. And they took it all the way through the appellate system, et cetera, and so forth. And in the end, the courts agreed. Why? Because the declaration gave them a pass. So my question is, when is the last time all you listeners out there looked at your collection foreclosure language in your declaration to see what it says? Do you need an amendment to that language to protect the association in the event of a third-party purchase? Because I can't tell you the number of declarations I see that gave a complete pass to the purchaser under those circumstances. And then, you're getting nothing at that point at the end. Sorry to interrupt you.
No, that's okay. The only thing that I will point out, and I agree, you're getting nothing from the third-party purchaser. But the thing to keep in mind is when you have a third-party purchaser, meaning the lender was outbid at the foreclosure sale, there is the possibility of having surplus funds available in the mortgage foreclosure. What that means is the lender was owed $100,000. The property sold for $200,000 because it's worth a lot of money. Well, that $100,000 that's left over is money that all of the junior lien holders, including the association, now get to fight over. So if your attorney finds that the association was wiped out for all of the pre-title meaning before the transfer of ownership. All those pre-title assessments, interest, late fees, attorney's fees, and costs that you spent. One way of getting that money back and recouping at least some of it is by asking that mortgage foreclosure judge to disperse that money to the association.
And how do you get notice? How do you know? And this is where, Alan, that was a great point, and I'm just jumping in because if you don't have the association attorney monitor the foreclosure because you think it's a waste of money, well, now we don't have notice that there's surplus funds, and neither do you.
Right. Now you could be owed 10 grand in all of these charges. And what did you pay? A couple $100 to your attorney to make sure you know what's going on. So to Jeff's point, I fully agree. It makes a lot of sense, not only to monitor for potential surplus, but just to know when there's a new owner in the property, that's another person you could be sending demands to for payment of the future assessments. I mean, I've had communities that refuse to allow the law firm to monitor a mortgage foreclosure. And we found out 6 months later when they finally sent the account over because no one was paying anything. And I said, well, this property changed hands 6 months ago. Have you sent a demand to the new owner? The notice of late assessment that you just waited 30 days on is without any merit or value at this point because you sent it to the wrong person. So, Jeff, I fully agree. Associations should be monitoring what's going on with those cases, whether that's through counsel or some other program. I think it's important. The other thing that I wanted to point out when we talk about, for example, a master association that might foreclose, if it's an association foreclosure and there is no third party, because if there's a third party bidder at the association sale, that means the association's paid in full. Fantastic. We go away happy. If that's not what happens and the association ends up with the property, you can then decide what to do with the property. So it doesn't, just because you own the property doesn't mean you can't sell it, possibly for fair market value if there's no mortgage, or try and get rid of it, sell it to an investor. Or I have some condos in Brevard County who have been renting units. They have 2 units and they've been renting both of them for 3 years because the lenders haven't foreclosed yet after someone passed away. So you have that now income, and we're not going to get into taxation, but you now have that money coming in, and it's certainly offsetting whatever you would pay to that master. If you're getting rent, unless the master assessments are absurdly high, you're probably recovering more than what you're putting out. So,
and if you involve the attorney in the collection process, Alan, right? If there's a tenancy situation, the association can make demand on the tenant to pay their rent directly to the association. Again, you really should do that through legal counsel so that you're telling the owner what they need to know and you're telling the tenant what they need to know in order to perfect all of that. But then the association has a lot of power as well over the tenant if the tenant doesn't start paying the rent directly to the association. So if you have an owner who's delinquent and they have a tenant in the unit, there's another little remedy for the association to try to implement to try to make itself whole.
agreed.
It's definitely important to have the attorney involved in this process, because I think when I'm sitting at a board meeting and the number one question from your board is, well, what am I going to be responsible for if we do foreclose? Taxes, like there's all sorts, the real estate taxes, like they don't know what it actually involves.
And they're not going to be responsible for those taxes, of course. But if those taxes don't get paid, and that's a whole nother lecture we could talk about sometime, a little offshoot of the collection foreclosure process, is what happens when someone doesn't pay their real estate taxes. And then everybody gets wiped out. The association gets wiped out. The lender gets wiped out in those processes. So there are decisions to be made.
And Jeff, I think you raise a good point also. Same thing applies with a mortgage foreclosure. I mean, there are very similar concepts to mortgage foreclosure. Well, what happens if the lender forecloses? You're not going to owe that mortgage amount just because you ended up with ownership. The lender can foreclose if you don't pay it, but you don't have an obligation. There's not going to be a money judgment against the association because you didn't pay the mortgage, because you didn't sign the note or the mortgage. So those are things that I've heard people being concerned about and choosing not to foreclose until they got that legal guidance that, that we're talking about here. Lisa makes a good point. If you're not asking for advice, you're guaranteeing that you might not be doing the right thing. And your attorney, if they're knowledgeable enough, will be able to give you the guidance of, no, you're not taking on responsibility for the taxes. You're not taking on personal responsibility for the mortgage. But both of those might wipe you out at some point in the near future if they're not paid.
Marita, I think we're coming back to you to guide us to our next little area here. I think we've covered safe harbor. That's the shorthand term we use to discuss the lender liability for the delinquent assessment, which we already discussed, 12 months back assessments or 1% of the initial mortgage, whichever is less. But of course, then the lender does have to pay the assessments going forward if they end up entitled. But as to the arrearage, they get the safe harbor, the statutory.
Jeff, one thing we didn't talk about
that
might be a bit concerning, but I want to make sure we at least mention it. When that safe harbor kicks in and that foreclosure sale happens, there is case law that clarifies the only thing that carries over to the new owner jointly and severally, like you mentioned, are the assessments themselves. So the interest, the late fees, the attorney's fees, the costs that were incurred against that prior owner, that's going to be kind of an association expense unless you can recover it from the surplus.
Correct. Which is why it's interesting, because many declarations say the association has a lien that relates back to the initial date of the recording of the declaration. So it has a lien, but it's not out there in the public record per se, recorded against that particular piece of property. So it's always, I think the association is in a better position when it has that lien actually recorded. And going back and clearing out the cobwebs from my brain, I do want to point out that once you record that lien, the association the condominium association only has 1 year to foreclose that lien. And if not, they have to start the process over. Whereas the homeowner association actually, I believe, has 5 years, I think it is, Alan, to foreclose the lien. And if not, then they have to start over. Now, obviously, you shouldn't wait that long in either case, but sometimes there are extenuating circumstances and such.
And keep in mind, some of those statutes of limitation that Jeff is mentioning might be determined and delayed a little bit by a bankruptcy that gets filed.
And a bankruptcy does what? It stops everything in its tracks. It stops the management company from sending more letters, you're delinquent. It stops the attorney right in the middle of the foreclosure action. We have spent 3 years getting there, getting ready for the auction. We're ready to go. And the owner declares bankruptcy and we're done. But here's what a lot of people don't understand about the bankruptcy. Once the property comes out of the bankruptcy, we can try to recoup some of those monies. Think about it as being temporarily delayed rather than being totally screwed out of your back assessments. Alan, you agree?
I do. And the other thing that people seem to always, or frequently at least, be concerned about is, well, they're in bankruptcy, we're going to get pennies on the dollar. That very rarely happens with a community association because you're what's called a secured creditor. Jeff mentioned you've got that lien in most instances that's going to relate back to the date of recording the declaration. What that means in bankruptcy court is that you're almost always going to be treated as having more of an interest in the bankruptcy estate, that person's property, as compared to, let's say, someone that's got a judgment against them, someone that's got credit card debt. So you generally will recover unless there are very specific circumstances where, one, they file a motion that says there's zero equity in the property after, let's say, usually the first mortgage is paid, and two, you fight it and they actually get an appraisal to prove that fact. So if there's any equity in this property, the association's either going to be paid inside the plan, meaning over 3 to 5 years, or outside the plan, meaning you get relief from the bankruptcy court and you go through your normal collection, even though the bankruptcy case is going on. Now, as Jeff mentioned, do not mess with what's called the automatic stay. Okay, this can result in huge penalties, attorney's fees, costs, in some instances, the tens of thousands for sending a single demand letter. Now, the judges have a reasonableness standard when it comes to that, but yes, to Jeff's point, do not mess with the automatic stay in bankruptcy. When you get a notice that pertains to bankruptcy in any way, shape, or form that goes to your attorney, do not think twice, do not pass go, do not ask questions.
Well done. Well done.
So Jeff, at this point, do you want to jump onto the Florida Consumer Collections Practices Act?
Sure, just a few things about it. So we talked about the Federal Fair Debt Collection Practice Act. We discussed how it certainly applies to attorneys involved. It, as of now, doesn't yet, at least in the appellate law, apply to the management companies and the association itself. Then there's the Florida Act as well, the Florida Consumer Collection Practices Act. And I'm not going to go through the whole act, and Alan, you can jump in if you think I miss anything or you want to add more. But here's what you need to know at the association level, because it applies to the association, the management company, the attorney, and it goes on from there. Number one, you cannot scarlet letter a debtor. If you take action to embarrass a debtor, then it's actionable. So that is why you would hear Alan and I always suggest to the board when they ask us, don't mention the name of the debtor during the board meeting. If anything, and you need to make a reference the property address, but not the name of the debtor itself. Do the best you can to not give an opportunity to your adversary to torment you. And that's an easy one to avoid. You cannot disclose to a person, other than the actual debtor, any or his or her family information affecting their reputation, affecting their credit worthiness. You cannot disclose information concerning the existence of a debt known to be reasonably disputed. So you're at the board meeting and you're discussing Joe's debt to the association. He's already disputing that debt. You don't mention it at the meeting. Now you're in violation of this Florida provision in the Florida Consumer Collection Practices Act. You cannot publish or post, or even threaten to publish or post, or cause to be published or post to the general public the individual names of the debtors, commonly known as a deadbeat list, for the purpose of enforcing or attempting to enforce collection of the debt. So if you were to put, as attached to the minutes, the names of all the debtors, or on the agenda even, the names of all the association debtors, and you're teeing it up, you are intentionally putting their name out there and opening up the association to some significant legal exposure if they get an attorney and they want to pursue those particular claims. Easiest way to stay away from it, don't scarlet letter the debtor, don't reference them by name at the board meeting. Very simple agenda item. Consideration of association collections, consideration of foreclosures. You could be very generic in your what's going to be written and published to the community. Then at the meeting, we can discuss the address at 102 Arrowwood and the fact that they are 90 days delinquent. Very easy to get around.
I will tell you, Jeff,
process.
some of the board members, unfortunately, and I've heard it in a board meeting, or they may be at a social gathering where they're talking to other neighbors, and I don't think they realize the ramifications of calling someone a deadbeat, of saying how much money they're owed, of talking about, the personal situation they may know about them. I try to tell the boards, it is such an exposure for them to be having those conversations.
Direct them to someone that wants more information. They are welcome to inspect the records of the association, and they can see the debt for themselves right then and there.
Right.
So
that was actually the one thing that I wanted to add, Jeff. I think you covered it well. Was that, I do get questioned frequently from managers, directors, well, if we're not allowed to give this information out voluntarily, what are we supposed to do if we get a records inspection request? And the answer is you produce those records for inspection. That is part of the official records that every member is entitled to. Now, you're not going to give it to everyone in the world. You're going to give it to the member and their representative, and that's it. But yes, that is an official record that's subject to inspection. The other thing I will point out that I've had questions about is if there is an existing lawsuit. People ask, well, what the heck's going on with the lawsuit? My response is always, you can give them the case number, and that's the extent that you go to. And if they want to look at what's already in the public record, which either the owner filed and allowed the public to have knowledge of, or we filed knowing that we are going to not violate these laws that we're talking about, yeah, everything that's in the public record, go ahead and direct them to it. But I would not be handing out any other information other than what's in the public record or the official records of the association for the reasons that Jeff mentioned.
good advice. Good advice.
So Jeff, in closure, before we possibly take some questions, I know you have a unique foreclosure program that Kaye, Bender, and Rembaum offers. Would you like to explain that a little bit to those present today?
Sure. We have, collections can be done under our general retainer agreement, but then you don't get all the benefits. So we have a secondary retainer agreement where we advance all the fees and costs in the collection process so you don't get monthly billing. Now, I'm not going to say there aren't times where the association ends up responsible for a period of time to pay us. Let's say the owner goes into bankruptcy. Well, then in that situation, we can't proceed any further. So we need to get paid. All right. But generally speaking, we do our very best to get paid by the debtor and are very successful in doing that. So we advance all of the fees and costs in the collection process. We go on autopilot as well. So unless there's a unique offer made by the debtor, we can continue moving the process along. We also have all the collections and the foreclosures. The process is in our online system. So I never get calls at my desk, which I love, about, hey, Jeff, what's the status of this collection? Because the board members, the managers, they already know. They get their user login and password. They can go see it and look at it to their heart's content. Let's see if I'm missing any of the benefits. I don't think I did. There is one thing to include. We do charge a small fee of about $450. Maybe it goes up to $500 per association that wants those benefits. And we even have more of a blended fee, which I think works out better for the debtor because it's not at our regular hourly rates, but more blended between paralegal and attorney for those associations that are in that program. You could have 15,000 collections. It doesn't matter. It's one time per year, that $450, not per collection matter at all. It just gives us a little bit of seed money to be able to be in a position to advance all those fees and costs and continue to do it, especially at the beginning of any fiscal year. So that's where that money really comes in handy and helps us offer those benefits. Not a requirement in any way, shape, or form. I certainly have clients that are not on that program, but overwhelmingly, I'd say 95% are. And if they have more than one collection a year, I think it pays for itself over and over and over again.
And frankly, I think even if they have just one, it probably pays for itself because I've been with other firms, unfortunately, and they were charging more of a collection retainer per file than the $450 we charge per year as of now.
Good to know as well. So we're here. If you're happy with your lawyer, well, stay where you are. If you're thinking about a new lawyer, we'd appreciate it if you give us a call. If you're with Lang Management and everything is good there, you're in a very capable hands. If you're not with Lang Management and you're looking for a new manager, you ought to consider giving Lang a call. So that's what we're all here for. We're in the association service business service industry. I see something down there.
That was a reminder that there is a survey. If you could please do the evaluation everyone has access to that. If you can please fill out that evaluation. So for future meetings, we hear the good, the bad, or the ugly on what you think should or could be done differently. We'd really appreciate it. At least you're muted.
And no, nothing. And then Star Hedrick asks, what's the third thing needed when sending to the attorney? Well, that's an internal K-Bender Rembaum form. So we need the ledger. You got that right. We need the 30-day letter with the affidavit we prefer. Yes. And then the authorization to commence, authorization to proceed. It's just an 8.5 by 11 piece of paper that says, yes, K-Bender Rembaum, you are authorized to begin the collection proceedings. It gives us the official mailing address. And it's a form we typically provide to the association to fill out so we get that information. Alan, look through these questions. Jump on in. Marita, Lisa, everybody, let's get some of these questions answered. Marita, I see what you mean about your comment about sort of jumping in, but...
So I've got one here. Courtney asks about the difference between collection agencies versus having the attorney tackle your collection work. Most collection agencies are going to keep a portion of your assessments once they collect. They're also going to charge the interest and late fees, which they also keep for the most part. And they're also going to, in some instances, and I'm not speaking about any particular company, but a lot of times my experience has been that once they have the account, they don't pursue it as aggressively as I would like to see.
And wouldn't they also have attorney's fees and costs as well?
Yes. So they're going to charge all of that. Some of them will say we charge it to the owner. Some of them charge it directly to the association. There is one in particular up here in Central Florida that I know will not operate the way that I'm describing, and I'm not going to name names as to who is good, bad, or ugly. But bottom line, you know, an attorney is really there to collect for you. So when we are doing all of this collection work, our goal is to get you paid, not to necessarily just get us paid.
And if
So
a member,
the goal of the collection agency is for them to get paid. Our goal is, as a fiduciary of the association, doing what is in your best interest, and that is rarely going to be you taking those assessments, which, like I mentioned earlier, are intended not as profit, but to just make sure you can operate correctly.
all right, now listen, if you go that long on every question, we're not going to get to any questions.
I have one that I think a lot of
Very
people ask
complete
across
answer.
the
Go
board
for
from an
it.
owner. If a delinquent owner offers to make a partial payment, should we accept it or only take payment in full?
That's easy. You must. Alan said, say that again a little louder for everybody.
You have to accept it. Otherwise, there is, and Jeff, I'll let you explain this a lot briefer than I can, but there is a possible waiver argument if you do not accept that payment.
And if they go to court and say, Judge, I tried to pay and they wouldn't take my money, oh, what a mess in the courtroom that's going to be. And judgment is likely going to be for the debtor in that scenario. If somebody offers money to pay their debt, you have to take it. You can try to say, hey, the account is with the attorney. Would you please contact the attorney to make the payment? But if they're insistent on giving it to the management company, then the management company needs to take it and they need to go ahead and tell the attorney what happened right away so everybody's ledgers get adjusted correctly. And usually I know that the management companies do direct the debtor to the attorney and then the individuals pay the account when it's here. That's the better way to get it done. But you cannot refuse to take money in a debt situation when somebody is offering to pay. So that's an important one.
Another easy question I'd be able to answer. It says, what happens if the owner sells before you get to the lien point? So if a homeowner sells before that, there's an estoppel that's required for the closing. And that's where
you're assuming, wait a minute, you're assuming they asked for the estoppel. So to go to that person's question,
Yes.
and it just happened the other day in a real world situation. It is wonderful. Are you kidding? If someone closes on that piece of property and there was money owed and they didn't ask for an estoppel, that new owner is just sock it to them, go get them, right? They owe everything. Now, if there's an estoppel, then you can put that money on the estoppel form, and then at closing, typically the closing agent will then make sure the association gets its money because it was listed on the estoppel. But if you issue the estoppel and you don't have the debt on there, or they ask for the estoppel and you don't respond within the statutory time frame, well, then no matter what the debt is, you're not getting it anymore.
Interesting.
Yeah, you better be timely in your estoppel responses because it's a full-blown waiver if it's not provided within the statutory time period. But it is a wonderful gift if they don't ask for the estoppel, because then they're fully responsible. The buyer is going to end up getting tagged for sure.
Jeff, correct me if I'm wrong. I thought it was just no fees and costs are due for preparation of the estoppel if you don't provide it in the statutory time frame.
I thought it was a full-blown waiver.
I hope I'm right. I might be wrong.
Dun, dun, dun.
Dun, dun, dun.
I have one question that came up actually in a couple of my board meetings, and I see it in the question and answers, because we're going to have the capability in our software pretty soon to be able to text if someone is delinquent. Is there any opinions on that?
I'm still thinking about that one. I didn't, certainly not from the attorney, right? We're not going to be texting anybody. If, I mentioned earlier, our manager does pick up the phone, right? And says, can you please call me? I wouldn't mind if that text message were the same nature. Hey, this is so-and-so management company. We have an issue regarding your property. Can you please call us? Or that is very different than, hey, you owe $500. You better pay it or we're sending it to the attorney. I don't like that.
You don't know if that phone number is the same or somebody switched it. That's what I'm worried about, because people change phone numbers all the time.
Generic is better.
Okay.
So we have one here. What determines if a mortgage is a first mortgage under the state law? Can a second mortgage graduate to first mortgage status?
Yes.
If they go to mortgage school.
What was that, Alan?
I said only if they go to mortgage school to graduate.
Cute. Yes. So it's order of priority. So the first mortgage was obviously recorded. You guessed it, first. If that first mortgage gets satisfied because it was, I don't know, $200,000 for the house, and then that $200,000 is paid, and there is yet another one in the public record, another debt, then obviously the person that the instrument in second position is going to be in first position.
What I do see occasionally is what's called a subordination agreement, which means that the first mortgage existed. They're now agreeing that they will take second position. But to Jeff's point, without that subordination agreement also recorded, my opinion is exactly what Jeff's just said.
So we have a question on here. Does the whole board of directors need to know how many condos are in legal?
What do they need to know? They should know.
Correct. I mean, that's a pretty easy answer that I wouldn't want any of your board members to be left in the dark on collection or what's happening with somebody who owes the association money. Just seeing if there's any new ones that you didn't answer.
I don't see any. I think we're good.
Yeah, I think most of these you covered.
So, Alan, so the estoppel has to be issued within 10 business days. I think on that we can agree. A fee cannot be charged for an amended estoppel certificate. So we know that as well. The association waives the right to collect any monies owed in excess of the amount specified in the estoppel. So if the individual, it doesn't get the estoppel, then it operates as a waiver.
So we have one other one here. Can a resident whose late assessment has been turned over to the attorney, can they ask and be permitted to ask for an extension? Is that something?
Before we get that, Alan, I think what you were thinking of is if the association receives the request and fails to deliver within the 10 days, then the association can't charge the fee for the estoppel, but they can still protect itself if it's pre-closing by delivering the estoppel. But if the closing occurs without the issuance of the anyway, if they've specifically requested the estoppel and the association didn't provide it before closing, then it's going to be problematic in collecting anything at that point. What was your question, Rita?
And we'll take this one last question. It was, can a resident whose late assessments has been turned over to the attorney, can they ask and be permitted to ask for an extension?
Yeah, that's up to the board.
Yeah, it's up to the board.
Yeah, if they contacted the attorney, you would just come back to us. We would take it to the board and ask them if they want to accept it.
If they're making an offer of some type, was that
Correct.
Yeah, I mean, what I would
say always, I would say always, we try to guide our boards that if someone is trying to pay and they're struggling, work with them.
Yeah, I mean, the only thing I'll point out is working with them doesn't necessarily just mean you say, okay, you've got another 3 months to pay. Working with them could mean we're willing to give you the time if you sign an agreement that says you'll pay in 3 months. And if you don't, we've got a streamlined foreclosure process.
Payment plan.
And we've had people sign up for payment plans that they had a hardship. You know, we had a homeowner who was going through cancer, could not work, and they worked out a plan. They weren't paying their assessments in full, but they were still paying until they could get back to a point where they could catch everything up. So, well,
we don't
want to thank Kaye, Bender, and Rembaum again. I want to thank Kaye, Bender, and Rembaum for doing this. Jeff and Alan, we appreciate the information that you're sharing, you know, with everyone in the associations. Lisa, thank you for your feedback today too.
No problem. Thank you, guys.
And please make sure you fill out the evaluation. It's important.
Agreed.
All right. Well, until the next one. And if you have any ideas for future topics, please share those with us too.
If you could put those in the evaluation, it'd be great. Thanks everyone for attending. We appreciate you being part of it.
Thank you.
Thanks for having us.
Have a nice afternoon.
Bye, guys.